then we also are trying to give you some sample forms, some template forms that you can just take away today for the people who are here. So we have here today an independent contractor agreement. We have an NDA, a non-disclosure agreement might be useful. And then 2 agreements related to intellectual property, an assignment agreement. So if a content provider is giving you something or should give you something, that's an agreement for that. Also an intellectual property licensing agreement. So that just gives you the use of the property, not the assignment. So anyway, and then we've got a whole bunch of other templates that we can send you, which we'll list at the end. Just make sure we have your email to do that. Okay. But today we're going to be covering a number of things about how to make, review, and enforce contracts, and then some common contracts. What I can do is at the question and answer time go over a few individual contracts if you have some questions about those. Okay. First thing to think about, here's the agenda. So we have a little bit on why to use contract, how to make a contract, how to read the contracts, a little bit about what we call boilerplate at the end of contracts there, and how to enforce. And then these are some of those sample agreements that we were talking about. So, all right, well, let's get started. So why do we use contracts here? Well, you have to think of it in a couple of ways. First of all, that an entrepreneur, one of the things that you do really well, or you're trying to do really well, is manage relationships. A lot of these kinds of relationships, and these would be, things with founders, other founders that you have, or workers, or capital providers, or suppliers, insurance companies, consumers. All of these different people will need to have agreements with you. And this is just a sample of some of those kinds of agreements there that you might need to have in your sort of toolbox when you're trying to create these relationships. And one thing to think about is it's important to have these in place when things go right, of course, and then when things go wrong, of course. And why is this? A number of people say, well, what about my family members? What about, I'm getting some money from an uncle or something. Do I really need an agreement? Well, here's the thing, it's about clarity. It's not about trust. I mean, there's some cultural issues, I suppose, that we have to pay attention to. People feel like my handshake is my bond kind of thing. But, your brain might forget some different things. So, especially when some of these agreements are more than just, hey, can I come over and cut your grass now and then? Okay, well, sometimes agreements are a lot more complex than that, and you want to make sure that there's clarity. That'll smooth things along as you're trying to get your business going. So here's one other aspect here, is it does make your business look more serious, especially to investors. If somebody comes along, you got a key supplier agreement going on, but it's a handshake, yikes. I mean, any investor is going to say, that could break down at any moment. So important to have contracts. You'll often be asked for them when you get stuff. Well, here's a good example. A bank will probably ask you for a copy of your lease if you have a lease with somebody. So good thing to have in your files there. So let's think about a little bit how to make a contract here. In law school, what we learn is that there are 3 steps to making a contract here. An offer, which is then accepted. The thing to note here is on the same terms here. So what we're talking about here. So Kevin, hey, handy dandy little thing you see, look how it works. It goes back and forth. Wow. Hey, how about I sell this to you for $5?
$5. That's a bit steep for my blood. Let's go for, how about $4?
Okay. All right, well, now what you should notice here is that my original offer of 5 is now extinguished because he counter-offered. So now you always think of it as, okay, my offer, no more. He made an offer to me of a counter-offer of 4, so I could accept that. Or I could say, no, I really feel strongly about my 5. Yeah, I'm going to keep this.
But if I had accepted the initial offer, Bill would be locked into selling me that item for $5.
So that's the way it goes. If you make an offer, it's supposed to be something that is communicating to a reasonable person that you're ready to be bound right at that point. So if I had said to Kevin instead, I'm thinking maybe I'd give you this for 5, that would not be an offer. It would be seen as a solid offer. So he could turn that down and it would still be, well, it wouldn't be an offer
That's right. It would be termed an invitation to bargain.
Yeah, an invitation, that's right, yeah. So then, of course, we were talking about consideration. What's the value that would cement the contract there? And that's a very important part of the contract, because even if you're having somebody working for you, yeah, would you come and work for me for free? Well, yeah, somebody could do that out of the goodness of their heart there, but it wouldn't be a contract until you actually exchange something with them. You know, hey, you work for me and I'll like you on your Facebook page. Okay, well that's enough. That's actually enough of a consideration there, even if it's not in dollars. It could be stock. It could be something that they get in exchange for you. So one thing we point out for that, for example, is if you're in an agreement as to forming a business, like a limited liability company, for example, is formed by an agreement. Many people just sort of exchange the promises, but they say, oh, we won't put anything in the bank right now. Well, that might not be seen as a contract, because you each have to put something in. It's sort of this bargain that you're giving. So make sure that your contracts also have consideration. Now there is this fourth part here, 1, 2, 3. There is a fourth component, which is that there are no defenses that would otherwise make this contract unenforceable. And probably the biggest one is what's called the statute of frauds. Statute of frauds. My sister kidded about this in law school, calling it the statute of frogs, but it's actually the frauds. Okay. A statute of frauds is these are contracts that have to be in writing under state law to be enforceable. Okay? So one of them is, like a prenup, paying somebody else's debt. Here's a critical one: an interest in property of greater than a year. So that means technically, if you rented something for less than a year, it would not have to be in writing. Should it be in writing? Yes, it should be in writing, but it doesn't have to be. And a couple other things up here. Oh, this is an important one, probably sales of goods over $500. That's okay. So those are the main defenses. I suppose one other defense would be if you were like pressured into it and you didn't really, it wasn't your voluntary act or something like that. But most of the time, it's the statute of frauds is the defense you got to worry about. Okay. Now the idea is this is supposed to be a meeting of the minds. All right. The parties must intend to create this contract. Parties, they have to agree on the main terms. If they just said, let's say you were a painter, and I said, could you paint my house? And you said, yes. Okay. Well, is that a contract? Well, even if we had some consideration on it and then you backed out, a judge might say, well, is that enough? Are there enough terms in this agreement to enforce it? So painting my house, well, you don't even know where my house is, and we didn't say anything about how much. Maybe I gave you some money, but that was only a down payment. We don't know from that. Maybe we don't know when it's going to be that you're going to do this. So make sure you have at least some payment terms, timing. If it's going to be a particular place, name where it is. Then more likely, even if you didn't fill in those things, even if you didn't fill in other things, a judge would enforce it. Let's see, the bargaining here, I think we already covered this part. Oh, here's an important part. Past acts don't count. So, if I said to Kevin, hey, so let me have you buy this, we'll take into account that you took me out to dinner last week. Okay, well, that wouldn't be consideration because it already happened. We needed a deal that's going to be, his future consideration there. And here's one, if, let's say you called up and said, hey, my house is being broken into here. And the 9/11 people said, well, how much is it worth for you to come over? Well, they're under a pre-existing duty to do something for you. So that's not really a contract. And it can be just, a little $1 is enough for a consideration here. This is why, for example, when somebody like a friend is like doing your website for you, at least put like $1 in for it or something like that, so it won't be seen as an illusory sort of gift kind of thing going on. Okay? So let's see how to read contracts. Oh, and by the way, if you have some questions, we can. Why don't I zip through this and then we can do those. So how to read contracts. Now here's an interesting point, is there are 5 areas common to most contracts. Right? So even if you haven't seen a contract before, you don't, it seems complex to you, look for these 5 things in a contract, and you'll get most of the important stuff. Okay, first is, of course, how does it deal with money, right? And not just, oh, well, here, let me give you the ones first, and now money, how does it deal with risk that's going on? Somebody could potentially get damaged, or, somebody could not fulfill the contract or something. Control, how much control are you giving up in order potentially to manage your risk? Here we go. Control and risk are sometimes related to each other, because the person with more control should have more risk. Standards. Now, this is a funny one. I might want to rename this, but the basic idea is sometimes contracts will have standards in them that are a little fuzzy. So let me think of one. In a residential lease, if anybody's renting here, like me, I might have in my lease something like, when you leave, you have to leave the property room clean. Room clean. Well, I guess that means that you're supposed to sweep it out, but you don't have to vacuum. I don't know, I guess so. But then it'll have stuff like, well, you have to, conduct yourself in a way that doesn't disturb the neighbors. Okay, well, what is disturbing the neighbors? This much volume, that much volume. So when you see standards in agreement, I would say be a little skeptical. Sort of say, okay, have we reasonably defined this enough? Well, here's one that probably would leap out to you. Pay me within a reasonable time. Okay, well, you might want to put down, got to be by the 10th of the month. Even have a little late fee if it's past the 10th of the month. Anyway, but some contracts will just sort of leave these vague terms in there, and you just have to decide the other person whether they're going to take advantage of that or not. And then, of course, when the contract begins and when it ends. So here, I just told you about all this stuff. Okay, here we go. All right. So let's go to the next thing. Now, here's another thing. For most lay people, when you're looking at a contract, it can look kind of legalistic. It can be kind of confusing, language that goes on and all this sort of thing. So what we suggest is, if you feel like you're getting snowed by the legal language there, these are sort of the most common things you'll see in a contract going forward. So just expect to see these sorts of things. So this way, when you read the language, you won't go, what does all that mean? You'll say to yourself, oh, okay, a covenant. Okay, these are just promises. Promises, I'm going to sell this used car to you for $10,000. Let's use a car example, okay? I say I'm going to use this used car, $10,000. You ready? Okay. That reasonably clear 10,000, pointing to this car, so you know exactly what it is. Maybe we didn't fill in terms about when and what is going to be cash or credit, whatever. Now here's another promise related to cars. You want to know probably how long it's been used, right? You want to know if it's running. You want to know if it's got that many miles on it. Well, this is what's called a representation. Okay, it's a fact that you're giving to somebody to induce them to get into a contract. Okay. But then here's the thing: representations have warranties that back them up. It's really a promise that backs up the representation. So this one, if I use the same one, I would say, well, if it turns out that it doesn't have 50,000 miles on it, it's more than that, then I will give you a comparable amount off every 10,000 or something. Here's another one. This used car is in good working condition, but if it breaks down within 90 days, then you can waive the sale. So look for those kinds of warranties in there. It's sort of a representation backed up with a promise. And then finally, this is a critical one where people kind of get tripped up sometimes. There are conditions in contracts, meaning something has to happen before the other person has to perform. So, for example, if we were doing this car thing here, maybe we would set up that I get to take the car. Let's say I'm buying it from you. Okay, I get to take the car to a mechanic to look it over, and then if they think it's okay and I'm ready to buy it, then I bring the car back. You give me the keys. I give you the money. Okay, so think of that as a condition precedent to our thing is I have it checked out by a mechanic. Okay, but then when it comes back, we have what's called concurrent conditions, meaning I'll give you the money, you give me. So just know that in your contract, it should be set up a little bit, these promises in order, so you know when you're ready to perform. Because if you give me the car to go to the mechanic, now your performance is done. It's now on my side that I have to come back and say, I'm ready. So, okay. All right, a couple of things. Here at the end, again, this is how you read contracts. Now I point out here, this is the fine print at the end, what's called the fine print at the end. Now a lot of people think the fine print is where they're gonna chuck in something sneaky and then you don't actually own what you're doing. Actually, no, the fine print is what everybody agrees on. It's sort of the standard stuff you'll see in any agreement here. And here's one of them. What happens if we get into a dispute? Okay, you can maybe say, well, instead of going to court, we're going to do mediation, and I'll go over how to enforce the agreement in a few minutes. But it basically says, look, already we've planned if there's some sort of dispute. Integration. This is a really critical one. Okay, what this means is that if you have done some negotiation, okay, that at the end of that negotiation you have a written agreement that came from the negotiation. The presumption is that everything you talked about and everything you promised is in this final agreement. So it's fully integrated promises that you've done, right? This means that if you have any oral agreements, you need to look over the agreement and say, okay, wait a minute, we talked about, this wasn't due till next month. Oh, well, it's not in here. Well, if it's not in here, the presumption of the judge is it's not there. Okay. So now you should know there is a way to save things a little bit. So if you don't have a clause in your agreement that says this is a fully integrated agreement, then the judge will say, well, I don't think the parties here said one way or another whether this was a full agreement. So I'll take some extra evidence. Now remember, if you're in trial, this is like expensive land. You don't want to be there. Okay, so instead, get it all in there at once. Modifications, usually people say, it's got to be in writing. We had a contract last week where somebody said, well, I can change the terms anytime I want to. You can't. That's not actually an agreement. That doesn't qualify as an agreement. A judge won't enforce it. It's got to be both sides. Oh, you might say to yourself, oh, wait a minute, I go on my website and it says they can change the terms anytime without notice to you. Well, that's true, but when you go on the website after they've changed the terms, you have the chance to go, oh, I don't want to do it anymore. Whereas in a written agreement, you can't do that. That's why a judge won't enforce it. Assignments are important. Just so you know, many assignments, if you want the person to do, like let's say you hire, like Desiree, for example, Desiree, to do your marketing, she's the best. I want her, okay, and that you'd want to know assignment clause in there because she could go, wow, I'm, can't do it anymore. I'm going to have my, little brother do it, and my little brother is not any good. So you want to make sure that's in there. No assignment, right? Okay. Now, here's one other thing you should know is there's something called in this assignment third-party beneficiaries. What is that? Okay, let's say that I want to learn Taekwondo. I arranged with Jackie Chan to teach me Taekwondo. Wait a minute, I'm sorry. I want to give you a gift of learning how to do Taekwondo. Awesome. And I've hired Jackie Chan to do this. Excellent. Okay, this is great. And Jackie Chan knows that I'm paying him and you're the recipient. Okay. What I can do, what I just set up is called a third-party beneficiary situation, because if then Jackie Chan goes, I can't do it, sorry, then we can both sue him. Oh. Yes, not just me, but you, because you're the intended beneficiary. So, let me see, just a couple other things. Governing law, that's pretty straightforward. Notice you should make sure that you have information in the contract. If you need to send a notice to each other, then where does that go? Severability is a thing that essentially says, hey, if one of our parts of the contract isn't good, then still the rest of the agreement is good. Okay. Force majeure. This means if something happens that none of us can control or foresee, like an earthquake or something like that, then the contract doesn't have to be performed. And waiver, this is an important one, if it means, yeah, like if I said, hey, can I pay next, can I pay like 10 days afterward? And you go, okay, I can do that. That doesn't mean you waive that forever. That just means that. All right, I think that's everything. All right, breaking a promise. These are the things you can think about. I mean, you can do nothing. Maybe it's too much hassle. Maybe it doesn't really mean that much. Negotiation, yeah, roughly 80% of the cases that people have disputes on will be negotiated out. Mediation is where you hire somebody or somebody's willing to help you work out the terms of an agreement, but they can't impose an agreement on it. Okay, that's arbitration. Arbitration, usually you set that up in an agreement where one side gets to pick one arbiter, the other side gets to pick another arbiter, the two arbiters pick a third arbiter, and then you probably lost all your money by paying all those three people. But yeah, that's the way it works. It's like private court.
So who pays for that?
Well, that's the thing. The parties pay for that. Yeah, but it's still probably cheaper than that going to court, because that just costs so much money to hire an attorney, and then there's all this back and forth, and then continued, and all these things. Now, of course, if you get an agreement on either of these two, you can prepare a little order for a judge to put, okay, now from the mediation, we've got an agreed upon settlement. Now it's going to be a court order. And that doesn't cost much. Okay, well, those are the main things that we wanted to cover with you. Wanted to see if there were some questions, but I can also, if you'd like, if you see any of these agreements here that you'd like to talk about further, as I said, we've got in the back here the independent contractor agreement, which is actually a kind of a big topic right now. If you've heard of AB 5 that was just signed by the governor about how independent contractors work or not for classifying people, we can go over that a little bit. If you'd like, NDAs, this would be if you were sharing information with somebody and you don't want them to go off and run away with your idea, which may also be paired with an assignment of, hey, you're going to, this usually happens with an employee or an independent contractor relationship. You're going to create a marketing plan for me, and now I want you to assign that plan over to me so it's mine and you can't take it anywhere. Okay. IP licensing, that's simply, what would be a good example of that? I have a patent and you can use it, but you don't get the patent itself. I'm just letting you use it for a period of time. That's the licensing agreement. And then of course we got leases, we got founders agreements, all these other things. Promissory notes, like just a loan, basically. And of course, everybody knows about website terms of use that are annoying that come up on the screen and we agreed, yes. That's definitely a contract. So any questions? Anybody want me to go over any of these?
What is a founders agreement?
Founders agreement, that's very interesting. What that is let's say all the people in the audience here wanted to go into business together. It would be a way of setting up expectations between you before you form the entity. Okay, because the entity itself would have some promises and expectations in it. But the founders agreement sort of says, okay, we're going to get these basic terms down first before you form your entity, and just know that the founders agreement can be folded into almost any entity, a corporation or LLC. The most important terms in the founders agreement to know, we think of it as a triangle. So if you're starting a new business, I know you can't see this on camera, maybe you can turn the camera. So think of it as a triangle, okay? What money are people going to put in? It's called contributions. And then what money or profit or losses are coming out? Losses. This is what's called distributions. And then management, meaning how are the basic decisions being made here? Okay. Now, the most important part to think about here is, are these terms related to each other? So if you put in 1/3 of the capital Does that mean you get a 1/3 profit share? Does that mean you got 1 vote out of 3? You could set it up that way, that's fine, but it doesn't have to be that way. You know, somebody could just say, I don't have any money to put in, but I've got a lot of smarts and I can help you later. Okay, well, that's okay. You don't have to put in a contribution. You still get the full profit share. So maybe this is not related to that. And maybe it's not even related to this either. So you'd say, well, I got a lot of smarts on the marketing side. Okay, well, instead of us having 1/3, 1/3, 1/3 votes, how about, since you're smart on marketing things, if there's a dispute between us, you make the final call on the marketing. So if you can work these 3 things out in your founder agreement, you've got basically everything you need to go forward. And maybe you never form an entity. But as I said, this is easily put into an LLC operating agreement if you're an LLC, or it'll go into what's called the shareholder agreement for incorporation.
The commercial lease with extension to continue lease or
Yes.
to purchase?
Usually it's, well, that would be an option to buy.
Option to buy?
An extension, the reason we put the extension in here is because, well, yeah, it's pretty important if you've done all this, you know, renovation and branding and stuff, and you don't want to lose that. So, yeah. So we have samples of those. If you want to just tell us, we can give you a sample of those. You know what, let me go over the independent contractor agreement just real quick here. Now this one, I don't know if it's updated as to, no, I don't think it is. No, not updated to the, we're gonna do this. Okay, now it's called, this is all still true, meaning independent contractors are generally, you can't control them very much, like you can an employee. An employee, you can tell them, you gotta be here at this desk 9 to 5, you know, you gotta wear our uniform, you gotta take some training from us. Contractors, it's more like, think about a website, or think about a plumber. They know what they're doing. I need my drain unstopped. I need a website. Okay, thank you. I need it done by this date. I need the website to look a little like this. But they're going to work on their own hours. They're going to work on their own terms, their own materials. Plumber will bring his own plunger, and then they go away.
So is that going to stop like people like Microsoft or whoever who've been hiring contractors to actually work on the help desk? So they have to come in 8 to 5 and work help desk, and they were contract employees for a long time.
Yes.
So that's going to stop that?
That is pretty much right.
Wow.
Yes, that's true. Oh, and think about Uber. Think about Uber, which actually brought us all to the fore. So the second part of the test, so there's 3 parts now to the test of whether you could characterize somebody as an independent contractor correctly. Right? And the reason is that it's important is if they really should be an employee, well, then they've got a back wage claim that I believe goes back 4 years. I think the statute of limitations is 4 years. Okay, so that means if you mischaracterize them, you may owe a lot of money for back wages. So the 3-part test is, the first one is control. You can't control them very much, just like we said here. Okay. Second part, and this is the critical part for Uber or the Microsoft one you just said there, is are they providing a core part of your services here? Think of it like a daycare center. Core part of the daycare service is teachers, right? So teachers should be employees generally. Uber says, we will provide you transportation. Who's providing the transportation? You know, F85 says it's got to be employees. Unless they can, well, they're trying to shift a little bit and trying to say, well, but we don't actually provide you the transportation. We provide you a platform where you can find a driver. Okay, well, maybe they'll get away with that. I don't know. But the idea is if you're advertising a service, the main people providing the service should be. Okay. And then the third prong, which is also pretty important and new, well, I shouldn't say new. The Supreme Court, when they made this decision 2 years ago, said this has always been the law. Well, AB5 said, okay, well, if it's always been the law, let's make it clear on statute. Okay. And so the third prong is the people who are providing contracted services to you should be in business for themselves, meaning there should be some indices that they're not just doing this just for you, that they are an independent business themselves. Okay, So that's where, yeah, they're trying to address the issue that somebody will just drive for Uber and nobody else. Okay, well instead it should be somebody who, yeah, can drive for Lyft or can do a limousine service to the airport or something like that. So a good indication here is if you have your own business card, or if you have your own website, or even if you have your own entity. Yeah, like a plumber. A plumber is doing this for other people, right? So that I think plumber will fit all three of the parts of the test. Really. Okay. All right, so a couple of things you want in that agreement, just so you know, probably some confidentiality in there. If you're giving them some secret stuff that you don't want them to run with, our agreement has that. By the way, our agreement back here has the whole 3-part test all in and already, so it's ready to go. If they're doing risky stuff, like our agreement says, you got to get some insurance. You got to get some indemnification of us if you do things wrong. You should be in business for yourself. You should do it with such care that you don't need to indemnify us. You do it right the first time. And then, yeah, you should make sure who's supplying what. Generally, an independent contractor brings everything. And then, this is critical. IP assignment. So that website person, yeah, like we had a contract last week. Somebody was going to do a trademark, just a branding thing for somebody. And they said, first, here's a lot of things wrong with this one contract, I'll tell you this. One of them was, I will create this logo for you for $2,000. I will create this logo for you, and I'm not even going to check to see if it's infringing on anybody else's logo. Okay, you get it. And by the way, you have to indemnify me, the person giving you the logo. No, it's got to be the other way around, of course. And this last part is, and I'm not even going to give you the logo. You get the license to use it from me. And what that means is you have to keep paying for it on a regular basis. No, you pay $2,000. You should get the logo free and clear of anything else. Right? Does that make sense? So make sure that you put this IP assignment in there, because the presumption is if you don't have it in, it's not there. Whereas an employee, there is a presumption that if you have an employee working for you who makes some intellectual property, it is the employer's, just by presumption. But you still probably want to agree. Just leave. Okay, so that's an independent contractor agreement. Hope you have any questions about that. And there's been certain by AB5 a few people that have been exempted from this. So like I know my veterinarian now is exempted, doctors are exempted. So that means that they don't have to meet the 3-part test and can be contractors. But there's only a few people that have I can't remember, how did they handle journalists? That was a big one, I thought. Because a lot of newspapers, of course, contract with people, right? And so I do know that after the court case came out, that a lot of newspapers were saying to their common content people, no, you can't. Only our employees can do this. So that's a real problem. I don't know, there'll probably be some fix-ups, I'm thinking, with other people who are now going to go, whoa, I should be a contractor, and AB5 will be in that middle. Okay, well, that's, as I said, we can go back and cover any of these other ones you might have, but take samples up there. If some of the ones are, again, what we have is independent contract agreement, NDA, assignments, licensing. Yeah, and then, of course, with these other ones, we're happy to send you a copy of those.
Thank you.
Yeah, hope that's helpful.
Yeah.
Hope that wasn't too much. So come back next third Friday if you have other things you want to find out about. I think next third Friday, are we doing trademark? Okay. Sometimes we do this in a sort of funny format, so I think next time we're going to do What's My Trademark? The old game show in trademark. So anyway, come back next third Friday. We'll be here 11:30, and stick around afterward if you need some individual consultation. We're here, and also I will put up on the board our website. Make sure you got it. So this would be where you can sign up for office hours, free office hours every Monday, Wednesday from 11 to 2. And you'll be meeting with Kevin, mostly, probably. And you just sign up at our website, which is www.law.berkeley. berkeley.edu, and then /NBCLC, that's New Business Community. Okay. All right, well, thank you for coming, and we'll be glad to talk to anybody about individually after.